So now let's talk about working with employees who have COVID or who have a fear of getting COVID and how to deal with them. So in this section, we're going to talk about, first of all, and most importantly perhaps, is dealing with COVID positive employees and what rights they have and what rights we have as employers in dealing with them. Then we're going to talk about leaves of absence that are COVID related. That could be because either the employee has COVID, because someone in the employee's family has COVID, or because the employee has been ordered to stay home, or the employee's child, for example, their school is closed, as many of ours will be in this fall, and so they need to stay home to take care of their child. And then, of course, what benefits and rights employees have who get COVID, whether it's workers' compensation, paid sick leave, things of that nature. And then finally, we'll talk about what the government says we can do with respect to employees to protect them without violating their rights as employees to be free from discrimination and so on. Okay, so first of all, working with employees who have COVID-19. So typically the manager or the physician or the doctor gets a call from the employee saying, hey, I've been diagnosed with COVID-19. What does the employer do then? First of all, we tell the employee, if they're not already home, to stay home and don't come back to work for some time. We also ask that employee to identify everyone that they've worked with in close proximity. Typically, that's going to be someone they worked within 6 feet of for at least 15 minutes in the last 14 days. Once we have that list of employees, we should notify those employees that, hey, a coworker who shall go unnamed, and again, important to not name the coworker who has COVID, but a coworker who you worked in close proximity with, who we can't identify, has been diagnosed with COVID. Please monitor yourself. Here are the symptoms that you should look out for. If you're asymptomatic, you're free to return to work or stay at work. If you have symptoms, then please stay home and get tested. And then depending on your work situation, on the physical environment, either you share a space or you share a building or you share a common hallway, you may want to inform building management or the landlord that, hey, we have an employee with COVID, and that employee may have come into contact with other workers in the building, and so you may want to let those folks know that they should monitor themselves for COVID. Now, there's several types of leave that are COVID related. The most important one is going to be the Families First Coronavirus Response Act. This act provides for two kinds of leave, emergency paid sick leave and then emergency family medical leave to employees, okay? The type of leave that this provides is going to depend on the reason for the leave. And there's 5 reasons for leave, either because the employee is subject to a isolation or quarantine order from the county, the employee themselves has been told to isolate or quarantine, typically because they have symptoms or because they have COVID. The employee has identified themselves as one who has symptoms and is seeking a diagnosis for COVID. The employee is caring for someone who is either has COVID or who may have COVID, or if the employee is caring for a minor whose school is closed. So those are the general reasons for the FFCRA leave. The amount of leave, the amount of pay, all depends on the type of leave that is being requested, but it varies from anywhere from 2 weeks to 10 weeks, again, depending on the reason, and the pay varies from full pay all the way down to 2/3 of the regular rate of pay. Now, there is an important healthcare exception that would permit most, if not all of you, to basically opt out of FFCRA leave. And so as doctors, you do not need to provide your employees with FFCRA leave. However, you may choose to do so. And I would urge you to do so, and I'm urging all of my clients to do so, because it's going to keep a sick employee out of the workplace. The last thing you want is someone who either may have COVID or who has COVID coming to work because they need that paycheck. And if they come to work and they're sick, there's obviously a good chance that they infect their coworkers. In fact, we've had several clients who we believe have had coworkers infect others. And so that's really been a big problem for our clients. So I would urge all my clients to provide this leave, even if they're not required to. Another reason to provide the leave is that is that there's a tax credit available for this leave. And so even though it's going to cost you money up front, you're going to be made whole on the back end with the tax credits for any FFCRA leave that you pay. Work with your payroll company, and they will help you monitor and pay that leave separately, and so you can easily get that tax credit for that leave. So there should be a net $0 effect to the employer who provides leave under this act. Okay, so again, I encourage all my clients to provide this, even if they're not required to. Moving on to other types of absences or paid leaves, employees can use California paid sick leave during this COVID time, obviously, if they have COVID or really for any reason, including caring for a family member, whether it's COVID related or not. Importantly, types of FFCRA leave, some of them are not fully paid, as I mentioned, some of them only pay 2/3. An employee could use their California paid sick leave to supplement that 1/3 that's unpaid up to their accrual. Same for vacation time. An employee could use vacation time, obviously whether it's COVID related or not, and we would urge our employees to use that time to, again, minimize the chances that they come to work with COVID symptoms or with the COVID virus itself. One more benefit is workers' compensation. Governor Newsom some time ago passed an executive order that said that an employee who's worked within the last 14 days of being diagnosed is presumed to have contracted the disease, or the virus rather, at the workplace. Okay, so it's a presumption of COVID in the workplace if they worked within the last 14 days. Obviously, that does not apply to folks who work at home, but certainly folks who work at our offices and get COVID are going to be presumed to contract that COVID in the workplace, and so they're eligible for workers' compensation benefits. Now, the employer could dispute this finding, but frankly, I'm not sure how you would prove that the employee got COVID somewhere else as opposed to the workplace. But hey, you have that right to, as an employer, to dispute it. Obviously, an employer can compel that employee use paid sick leave before the workers' compensation benefits kick in. Now, I believe that this order, even though it seems harsh and seems a bit draconian, it actually benefits employers, and I'll tell you why. That's because workers' compensation is the exclusive remedy for an injured worker in California. That means that a worker's injured at work, whether it's carpal tunnel, slip and fall, what have you, a cut, a bruise, a back problem, workers' compensation is their only remedy. That means they can't sue you in civil court, they can't sue you for pain and suffering, they can't sue you personally, they can only file a claim within the workers' compensation system. And so that's going to be covered by your insurance, and it should be less of a headache, certainly it'll be less of a headache and less of a financial burden than if they were to sue you in civil court. Also, my understanding from workers' comp folks is that any workers' comp claims based on COVID are not going to affect your what's called your experience modifier, and so it should not increase your premium in future years, unlike other types of claims. So really, this is, in my opinion, a blessing in disguise to employers, because it's not going to cost you more, it's not going to cost you anything out of pocket, and it's not going to cost you more in premiums down the road. So really, it's more or less a win-win for an employer, if an employee does bring this workers' comp claim based on COVID. Now, we've got a lot of questions about employees who refuse to work because they have a fear of getting COVID, right? It could be a fear because because they're older. It could be a fear because they have a specific condition that makes them more likely to get COVID, or it could just be a should we say, less than well-founded fear, right? They just have this. They're a little freaked out by this virus, and they just have this fear, even though they may be, let's say, younger and healthy and really not in a risky category, but they had this really intense fear of COVID and don't want to come to work. What can we do? The most important advice we give clients is, let's not fire these folks off the bat, okay? There's strictly speaking, there's no protections for an employee who just has a fear of COVID. Now, if you get a doctor's note from a doctor saying, hey, this employee is under my care and they are at high risk for COVID, and so we would ask them to be put on leave of absence, then absolutely accommodate that request. Let the employee stay home. If they can work from home, great, but if they can't, then it's going to be an unpaid leave of absence. They also may be entitled to other accommodations under the Fair Employment and Housing Act, the Americans with Disabilities Act. They may also be entitled to leave under the Family Medical Leave Act and other statutes. And more importantly, giving employees flexibility when it comes to this virus is going to engender goodwill and hopefully make the employee stay with you for a longer time, and you're going to have happier employees. So generally speaking, we're telling employers, hey, absent a specific medical reason, let's try to be understanding. Let's try to be a little more open-minded than we normally would, given the sort of unprecedented nature, of this virus. So there's employees who either identify themselves as high risk and tell you, hey, I'm at high risk because I'm older, because I have a condition, or there's folks that you're worried about. Well, I know that John, is a cancer survivor. I know that, Jane has asthma. I'm really worried. I'm really worried about them. Or, hey, I have a lot of employees who are older. I'm really worried about them. What can I do? The answer really is nothing. Okay, it would be discriminatory for you as the employer to identify folks who you think are at high risk and tell them, hey, you can't come to work because I'm worried about you, or you need to stay at home because I'm worried about you. Now, again, if the employee comes to you and says, I have a condition, here's my note, I need time off, then of course accommodate that request. But absent that, as employers, as much as we want to, as much as we are acting out of a concern for our employees, we can't select the employees who we believe are at high risk and treat them differently than the employees who we think are not at high risk, okay? Again, if an employee has a request or a fear, let's try to be as flexible as possible. And of course, if you do have employees who are at high risk, you want to make sure that you limit their exposure to other workers and to patients and so on, right? And if we can, let's try to accommodate telecommuting. So if you have folks that work in billing or in patient scheduling, and we can have them work from home somewhat efficiently, then let's go ahead and do that. Obviously, our MAs, need to be in the office, and our nurses need to be in the office for the most part, and they can't telecommute. But if we do have employees who can't telecommute, then let's go ahead and accommodate them. Now, the state and federal government have given us some helpful guidelines about what we can and can't do. And these guidelines are actually quite employer-friendly. And if you told me a year ago the EEOC or the DFEH said this, I would have said you're crazy. But the EEOC, which is the federal agency in charge of handling complaints of discrimination in the workplace, and the state counterpart in California is the DFEH, the Department of Fair Employment and Housing, both have said that an employer can ask an employee if they're experiencing symptoms of COVID. Do you have a temperature? Do you have a cough, et cetera? Employers can also test for COVID. They can test employees for COVID. Now, when it comes to testing, a couple of important things. Time spent taking the test or waiting for the test is going to be on the clock, must be paid. The test itself is going to be at the employer's expense. Obviously, we want to make sure that we're using a reliable testing service and a reliable test, and all that. And importantly, we cannot test for antibodies. We can test for COVID, but not to see if an employee has antibodies that would presumably or possibly preclude them from getting COVID again. We can take temperatures. Most of our clients these days are taking temperatures at the office when the employee comes to work, and then sending any employees home with a high temperature. And again, we can force employees who have high temperature, who have other symptoms, or who test positive for COVID to stay home, and we can require a doctor's note before they return to work. And frankly, we should require a note before they return to work to, again, make sure that we're keeping our employees safe. So again, this is good news for employers, something that is fairly unprecedented, where the government is saying, hey, you can inquire about their health status, you can inquire about their symptoms and so on, because employee safety trumps their privacy rights to this health information. Of course, if you do have test results or employee health information, keep that separate from their personnel file. Questions about COVID in the workplace and employees with COVID or employees with a fear about COVID?
I have a couple questions here. The first is regarding to the payment protection program. Some practices did take out those loans in the hopes they'd be converted to grants. Does any of the leave time or anything like that interfere with their ability to be able to apply for the grants, or is there any considerations they should think about in those regards?
The only real interplay here between PPP and COVID, employees with COVID I can think of would be that any amounts you pay as FFCRA leave would not count towards PPP forgiveness. However, you do get a tax credit for the FFCRA leave, so really it's nothing out of pocket. But the only consideration there, again, would be that those wages or the FFCRA pay would not count towards wages for PPP forgiveness. Other than that, I can't think of any other interplay. Keith, can you think of anything?
Yeah, the one thing I was thinking of is if you've got back to maybe the fearful employee, or if someone has run out of paid leave, because we're getting pretty long into this now. Theoretically, someone could have run out, or as an accommodation, you say, okay, why don't you take a few more weeks off unpaid? That's going to affect your ability to hit your PPP forgiveness percentages dedicated to payroll, although those have moved in the employer's favor recently too. So you do have to be monitoring your overall numbers to make sure you're going to get forgiveness for a couple of different reasons there, and leave can do that, especially if it's unpaid.
You guys had covered, and we got a question in regards to testing. The timeline in regards to receiving results is a bit strained. Obviously, as the state has seen a higher influx of testing, are there any considerations given to employee time off as they're waiting for test results?
So an employee who's waiting for test results would be eligible for FFCRA leave for that paid leave. And so, yeah, while they're waiting, they will be paid. I know some folks are reporting it's taking up to 2 weeks to get results, which seems very long. But, you know, an employee waiting for results could have up to 80 hours of pay under the FFCRA. And so that entire time could be paid.
And then finally, there was a question in regards to PPE, so personal protective equipment. Are there any considerations given the difficulty of obtaining PPE? Is there anything in general terms that should be covered? I know that kind of goes in with what you guys had talked about in the previous section, but are there any considerations that folks should keep in mind in regards to PPE and their staff members?
Yeah, go ahead, Keith.
Okay. So assuming for the practitioners on this call purposes that we're not dealing with emergency proceedings, you need to be properly stocked on PPE. In a moment, I will talk about the CDC's guidance on PPE relative to patient exposure. But short of that, you know, if you're running low and can't provide the employee with adequate PPE, you're going to have to modify the schedule until the stocks can be brought back up. In all likelihood, there is, and it's fairly drastic, some guidance, but it's usually more in a hospital setting, an emergency setting, dealing with an influx of COVID patients, that in a hospital setting, the hospitals could require people to continue treating patients in more of an emergency setting, even if adequate PPP is not available. But that would not be our recommendation for, you know, outside private practices, where in all likelihood you could delay the visit or refer them to somebody else. So short of that, yeah, you need adequate PPE, which I think Jehan had already covered it in the discussion with OSHA and the like.
And I just want to highlight for participants, there is legislation right now being considered that would require both the state and private practices to maintain a PPE supply. Currently, OPSC is opposed unless amended to that legislation, with the request being that the PPE pipeline be stabilized before any requirement for practices to maintain certain stockpiles be implemented. So I wanted to add that really quickly. That's the last question I have in this section, but I thought that was pertinent for the discussion.
You know, Jehan, did you have a thought on PPE? I had a couple other things for you too.
I think PPE we've handled. One question I saw has to do with employer reporting COVID cases. Typically, employers do not have to report and really should not report any COVID positive employees to the government. That's going to differ county by county. For example, LA requires that employers report a cluster of COVID in the workplace, and they define that as 3 or more cases in the workplace. But again, that's going to depend on the county. Generally speaking, you're not going to be required to report a single case, I don't believe, in any county in California.
A couple of questions we've had from clients that might be useful for the group. Jehan, if you want to comment on it. With respect to the new leave laws, what are the expirations on those? Are they permanent at this point? And how do you take that into account?
Yeah, so FFCRA will expire on December 31 as of now. That could obviously change, but FFCRA is going to be around at least for the rest of the calendar year.
Yeah, I think when it was passed, the idea was we were looking at a multi-week or maybe a few months of all of this before it died out. Obviously, it didn't play out that way. So with the discussion of a new round of stimulus and so forth moving through Congress, I think that's one you just need to keep your eye on, whether or not that extends, because that was a big change on the employment side, and it might be gone in 2021, it might not, but as of right now, it'll be gone. Another question that's come up quite a bit does have to do with some of the benefits and the stimulus at the federal level. Is what if an employee is not interested in coming back, not because they have a particular rational or irrational fear of COVID, but they frankly are making a comparable amount of money by staying home and just prefer not to work and earn a similar amount of money. We've had that question a whole bunch of times to give you a sense of how much some of the folks are receiving in the government benefits. But what do you do with that employee, Jehan?
Well, I mean, that employee doesn't have a right to stay home, and so you are free to terminate that employee if they refuse to return to work without some kind of valid protected leave of absence, right? Whether it's FFCRA or disability-related leave. Without that leave of absence that's protected by law, they have no real protections, and they can be terminated from their employment. Yep. Also, to the extent that you get an EDD claim from them, let the EDD know, hey, this employee was offered work and declined it, and so shouldn't receive any benefits.
Yeah, I guess the only thing I might add a little bit on that is this time where there's going to be a lot of shuffling of people working at home, people in and out. It's very much less consistent than it may have been before all of this. But it's not a particularly good umbrella to just get rid of employees who you wanted to get rid of anyhow. It might serve that function. There might be a legitimate business reason for it, but I would anticipate an increase, a spike, if you will, in claims of wrongful termination and discrimination as a result of the layoffs that are coming from COVID or have already happened from COVID. And so, the person who doesn't come in because they're making more staying home or making comparable, that's fine. As Jehan points out, you can let them go. But at the same time, you need to be mindful of where what your documentation on that employee file looks like, so that it doesn't get spun into a improper or wrongful termination.